Start.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. This is Pam Mazza, and I am here with Katie Flood. Thank you all so much for joining us for this afternoon's webinar on the SBA's proposed changes to the limitation on subcontracting rule. We will be talking about the proposed rule today, and I'd like to first go over a brief overview of the points for discussion. First of all, hot off the presses is and the SBA's proposed rule for the new Mentor-Protégé program for all small businesses. As most of you know, the Congress had instructed SBA to establish a Mentor-Protégé program like the SBA's 8A Mentor-Protégé program for all small businesses, and on last Thursday, the SBA issued the proposed rule. So we'll just go over some of the highlights of that rule quickly first. Then we'll drill down on how the limitations on subcontracting currently work, the changes that were required by the National Defense Authorization Act, and SBA's proposal to implement those changes. On your screen you have a window that you can write questions in. So if you have questions, we may try to catch them during the presentation, but if we don't, you could expect an email from us afterward with our response. The slides will be available after the presentation on our website. All right, so let's start with the SBA's proposed Mentor-Protégé programs. So the proposed rule is in the February 5th Federal Register. If you want to read it, you can download and read that Federal Register notice. Comments are due on this proposed rule on April 6th. So our office has generated a client alert, which should be on our website, and we likely will try to put together some draft comments to circulate in the event that you would like to see where we're headed on this and utilize anything from those comments that you'd like to adopt as your own. So the new Mentor-Protégé program would create one new program open to all small businesses. It would allow the small business protégés to joint venture with their large business mentors, and mentors could own up to 40% of the protégé. So in that respect, this program is identical to the 8A Mentor-Protégé program. There is now a proposed participation period in this rule, and the proposal is that no more than 2 consecutive 3-year terms or a total of 6 are available to a protégé to be a protégé, so a total of 6 years. SBA must conduct a formal size determination before determining that a protégé is eligible, and I guess one of the thoughts is that there are about 13 other agency mentor-protégé programs out there, and so the fate of those programs, I think, is in question. What will become of them? Some of those programs are very specific to the agencies and really have value separate and apart from an SBA program. So we'll have to see what happens with the other agency programs. Only for-profit firms can qualify as mentors, and they have relaxed the requirements for protégés. So in other words, you just need to be a small business. The proposed rule also has several changes to the joint venture rules. The rule is asking for comments on the value of populated joint ventures. Can you hear? Thank you. So the rule is asking for comments on whether or not there is a value to having a populated joint venture, because SBA is thinking that the joint venture should be unpopulated in order to maximize the benefit to the protégés. So that would be a major change if they eliminate populated joint ventures. The proposal contains some inconsistencies regarding how partners can share profits, and so we need to drill down on those a little bit and ask questions for clarification. Joint ventures would be required to submit a certificate of compliance, and that, if it's false, could be subject, or non-compliance could be subject to suspension, debarment proceedings. 8A joint ventures would be subject to size protests. Right now, that is the rule. So if an 8A joint venture receives an award and someone thinks that the award is not small, going to a small business, then you can file a size protest. Hub zone firms may joint venture with non-hub zone firms. Currently, under the rules, hub zone firms can only joint venture with other hub zone firms, but this eliminates that requirement. And SBA is proposing the ability to disregard the claim of disadvantage for 8A eligibility if an applicant has not presented evidence to disprove the legitimate alternate ground for perceived discrimination. This was something that the SBA wanted to do because it was not necessarily clear the level of proof that was required for non-disadvantaged individuals. In other words, those who were not presumed to be socially disadvantaged to apply to the program. So we have to study that a bit more to see what it entails. So let's move on to the limitations on subcontracting rule. The first thing that I would like to say is that this rule is a little bit complicated, and there are a lot of ramifications to the proposed rule that need to be thought through. Sometimes you can't really tell what will happen with the rule until it sits for a while and you live with it. But right now, with respect to this rule, I think there are a lot of questions about how it will be administered, what the compliance measures are, and how contracting officers will be able to understand this new rule. So one of the suggestions from some of the trade associations, and one thing that we did today, was we sent a letter to SBA asking for an additional 60 days to comment, because this proposed rule was issued on December 29th and comments are due on February 27th. So, allowing the small businesses and industry groups more time to study it and put together statistics if they think that there is, an adverse impact would be helpful. And I remember when SBA issued its proposed major changes to the 8A program a couple years ago, SBA had public meetings that went around the country and had public forums in several states so that small businesses could come and comment on the rules. So maybe they will do that again. We're not sure. If you think you need more time to comment, though, it would be great to send an email in to Brenda Fernandez, who is the person on the Federal Register notice who is in charge of receiving comments. So what do we have right now? The current rule is that the limits on subcontracting are really based upon the amount of labor costs that can be subcontracted out. So as I'm sure you all know, for services contracts or manufacturing contracts, at least 50% of the cost of personnel must be incurred at the small business prime contractor level. For general construction, that percentage is 15%, and for specialty contractors, it's 25%. It excludes profits or fees from this labor calculation. And so I think that Congress, some members of Congress felt that it was a little bit difficult to administer and to be able to tell whether you were comparing apples to apples, prime to sub. So the Congress put a provision in the law in the NDAA to switch it to limitations on subcontracting. Currently, SDVO, SBs, and hub zone firms can satisfy the requirement through a combination of their own employees and another SDVO, SB, or another hub zone firm. So this, I think, is the birth of the similarly situated teaming partners that is in the NDAA, and Katie's going to talk about that.
So like Pam said, when the 2013 NDAA was passed, Section 1651 stated that they were going to change how the calculation of the limitations on subcontracting would be performed. As currently, like Pam was talking about, it's based on the labor and costs incurred for personnel. The SBA is seeking, and well, the NDAA and now the SBA is seeking to change that calculation to an examination of the total cost of the contract, not the cost of the contract incurred for personnel. The 2013 NDAA said that for service contracts, the small business, quote, may not expend on some contractors more than 50% of the amount paid to the concern under the contract. And for supply contracts, the small business can, quote, may not expend on subcontractors more than 50% of the amount less the cost of materials paid to the concern under the contract. So it's a total contract value calculation. The thought process behind that was, I think, and then the proposed rule says this in the background, to simplify the calculation, to make life easier, I think, for both contractors and contracting personnel at the agency to calculate these limitations on subcontracting and make compliance a little bit easier. The NDAA did not address what it thought the proposed percentages should be for the construction industry. They said that they would leave that to the SBA during its rulemaking. And the NDAA also discusses contracts that have a mix of services and supplies. And we'll see when we talk about that in a little bit how the SBA has grappled with that in the proposed rule. The law also envisions that SBA can change the performance percentage for a particular industry to reflect conventional industry practices amongst the small businesses in that industry. So they're trying to give a little bit of wiggle room to the contractors, NAICS code by NAICS code, and there's going to be, and the proposed rule does have some rulemaking that we'll see in the future on that. So it'll really depend on the industry and whether how organized the industry is for those particular subsectors. Another big change, as Pam was talking about earlier, is the establishment of the concept of similarly situated entities for meeting the target compliance for the limitations on subcontracting. And this is similar to what we see currently for the Hub Zone program and the SDVOSB program. So the law would allow small businesses to satisfy the limitations on subcontracting through a combination of the small business's work on the prime contract and any subcontracts to, quote, similarly situated entities. And that's a firm that qualifies for the same small business status required for the prime contract. And we have an example here in our slides. For example, if it's an 8A prime contract, it's an 8A set-aside contract, and the prime contractor is obviously an 8A qualified firm. They can satisfy that limitations on subcontracting through a combination of its own work, so let's say like 30% the prime contractor will perform, and subcontracts to another 8A firms for another 20%. But you can't count subcontracts to a hub zone firm, for example, or an SDVOSB. So so the proposed rule, the SBA was directed by Congress in the 2013 NDAA to release rulemaking implementing the new changes in the law regarding limitations on subcontracting. And that was what was released on December 29th, 2014 in the Federal Register. And comments to the proposed rule are going to be due on February 27th, 2015, as Pam was just discussing. We're planning on drafting up some proposed comments and releasing them on our website by Friday, this Friday. So if you need examples of some issues to spot in the proposed comments, the proposed rules, or would just like a model, those should be available to you. And besides the limitations on subcontracting, the proposed rule also addresses some other changes to the SBA's small business rules. And this includes identity of interest affiliation, joint ventures, subcontracting plan requirements, and the non-manufacturer rule.
So the proposed rule keeps the same percentages as current law and regulations, but now those percentages will be based on total contract value. So if it's a service contract or a supply contract, which would be for manufactured products, then the small business prime contractor must only subcontract out 50% of the total value of the contract, 15% for general construction and 25% for specialty trade. As Katie was mentioning, there are provisions for mixed service and supply contracts, and this is a little sticky, so we just need to go through it. What the rule says is that for contracts involving both services and supplies, the contracting officer must select the NAICS code that best describes the majority of the contract value. Now, that's not different from how contracting officers are supposed to designate NAICS codes currently. So the contracting officer selects the code. Then the code will determine which limitation on subcontracting applies. Is the limitation on subcontracting for services, or is it limiting for supplies? And the proposed rule makes clear that in no case would the limitations on subcontracting for services and supplies apply to the same contract. So really what we're seeing is that there are two separate standards, one for supply contracts and one for service contracts. The applicable limitation on subcontracting shall only apply to that portion of the contract award amount. And this is a bit unclear, and we even have some disagreement within the office as to what it means, but it appears to mean that on a contract primarily for services, you can exclude supplies. And then whatever's left after you exclude supplies, only 50% of the total cost of the contract, excluding supplies, can be subcontracted out. So it's limiting the service portion of the contract. We don't see a definition of supplies, so we're not sure exactly what that means. So for mixed supplies and services contracts, this is a quote from the reg, a procuring agency is acquiring both services and supplies through a small business set-aside contract. The total value of the contract is $3 million, with the supply portion comprising $2.5 million. That means that the contracting officer must assign a manufacturing code to the requirement. Then it appears that the services portion of the contract would be excluded from consideration, and a small business manufacturer together with one or more similarly situated small business manufacturers would have to perform at least 50% of the cost of manufacturing the product, or at least 50% of the $2.5 million. So this is an example right out of the regulations, and it excludes the $500,000 of services that are provided in connection with the manufacturing contract. Anybody wondering how contracting officers will be able to figure out what to do? All right, so now let's look at construction contracts. Remember, the law didn't put a percentage in, and that basically Congress invited SBA to do an analysis and decide what it should do for construction. Now, it's very interesting because the proposed rule does not exclude cost of supplies or materials for construction contracts. So the way we read it, that means that the costs of materials would be included in the total contract value. And then what I think that means is that you can only subcontract out 85% or 75%, depending on if it's a GC or a specialties trade subcontract, and that is based on total contract value, including materials and supplies. So it could have been an oversight that they didn't exclude cost of materials and supplies for construction, but I would really encourage everyone to ask and to send in comments about that, because our construction folks tell us that a general construction contractor really only keeps 3 to 5% of the total contract value, and that it would be very, very difficult to hit 15% if you had to do the percentage based on total contract value. Are you doing some more situation? Back to Katie.
So now we're going to, so besides the big change in the method of calculation, the second really big change in the limitations on subcontracting calculation is the utilization of the concept of similarly situated entities. As we talked about earlier, the law required that this be implemented into the regulation, and so now the proposed rule states that any work done by a similarly situated small business does not constitute subcontracting for this calculation. So a similarly situated entity is another small business that is a participant of the same small business program that the prime contractor is a certified participant of, and which qualified the prime contractor to receive award. So for 8A set-asides, other 8A certified companies, HubZone, SDVO, SB. Both the prime small business and its similarly situated subcontractors must perform the required amount of work themselves, and that means that the similarly situated subcontractor may not flow down work to a large business subcontractor. So this is really meant to protect against the flow down, to be using similarly situated entities as just a pretext to flow down work to lower tier large business subcontractors. So if through other similar situated entities a prime contractor is achieving its limitations on subcontract target, then those similarly situated entities will be expected to also be performing the amount of work that they said they will. And something else about the new rule is that you can count similarly situated entities at any tier. So it's not just your first tier subcontractors, but also second tier, third tier, all the way down the line. Of course, that creates more of a compliance issue. You know, the farther away you're removed from the prime contract, it's harder to keep track of. But in theory, it will work that way if you're using any of those similarly situated businesses to meet the percentage. Another concept introduced, or I guess exception, if you will, is that similarly situated entities will also be excluded from the ostensible subcontracting affiliation considerations. So if you submit a proposal and rely heavily on your similarly situated subcontractors for key personnel example, for example, or past performance, you'll be protected against an ostensible subcontractor determination if your size is protested. However, just a small caveat that affiliation can always be found for other reasons, so it always pays to keep close attention, but at least you won't have to worry about relying heavily on those similarly situated subcontractors. So when you're submitting your proposal, you're also required to identify the similarly situated subcontractors up front in the proposal. The rule gets is very clear on what you need to provide. You have to provide the percentage of the prime contract award that will be spent on each similarly situated entity, and a written agreement is required for all similarly situated subcontractors that the prime contractor is going to rely upon. And there's certain requirements for these written agreements. It must include a solicitation number, it must be signed by both parties, and it must be attached to the prime contractor's proposal. So teaming agreements that you enter into with your subcontractors, if you're planning on relying on them to meet the similarly situated subcontracting requirement, these teaming agreements are going to be increasingly important. And the proposed rule also says that it's not material, and that's a quote from the proposed rule, not material, whether the specific entities identified in the proposal actually end up performing the exact amount of work that you've identified them for, so long as collectively all entities are meeting the applicable limitation on subcontracting requirement. So you're not wedded to using the subcontractor for precisely the exact percentage you have identified from the government standpoint. However, it's important to keep in mind that you've signed and executed presumably enforceable teaming agreements with these people, so that'll be something that you have to keep in mind. And also, the proposed rule also says that SBA may consider any party's failure to comply with the spirit and intent of a similarly situated subcontract as a basis for debarment. So the SBA is going to be monitoring this fairly closely, and the implications can be big.
Let me stop you for a couple of minutes and answer a couple questions. One question was whether the size standard applies to the similarly situated entities, and the answer to that is yes. So whatever the NAICS code is assigned to the contract, you need to make sure that your similarly situated subcontractor is small under that NAICS code. And then another question was, if it's a small business set-aside and not an SDVO, SB, or 8A, or HUBZone, or woman-owned set-aside, can a similarly situated company be any small business? The answer to that is yes, so long as they're small under the NAICS code assigned to the procurement. Katie's moving to compliance issues.
Yes, as you can imagine, these new rules are going to cause quite a headache for compliance considerations, especially for how you report to this and how the contracting officers will be monitoring it. So the new rules contemplate that compliance will be an element of responsibility and not a component of size eligibility. So we're not anticipating that that contractors will be subject to size protests on compliance with the limitations on subcontracting. The prime small business must also certify its compliance with the applicable limitation on subcontracting with its proposal. So this will be a separate certification that you will be submitting as part of your offer. And if it's not apparent on the face of the offer that the prime contractor will be complying with the limitations on subcontracting, the contracting officer then has the discretion to go to the SBA and request a certificate of competency. So the certification requirement opens potential for suspension and debarment and other liability issues if false. And that's what we were talking about a little bit earlier too, with if you're not found to be within the spirit and intent of your similarly situated subcontracts. So there's some debarment issues that are being presented through this new rule. And we also have a question with regard to whether or not these certifications and or the limitations on subcontracting, if that's going to be an eligibility criteria for your proposal. So will that be something that you can take to as a protest issue before the GAO? Can you protest the CO's failure to determine compliance with the limitations on subcontracting, or their failure to refer the issue to the SBA for a COC? Those are issues that we're going to see kind of play out as the new rule becomes implemented. Right now, we've definitely seen protests before GAO where they have found that the proposal did not comply with the limitations on subcontracting on its face. So those are issues that the GAO is looking at now. So it just remains to be seen whether that will continue to be. And then another issue with compliance is that if the prime contract award is modified after award, the prime contractor must notify the CO if it is no longer able to meet the applicable limitation on subcontracting. So all of that needs to be documented and kept with the file.
So we were talking to some clients this morning, and they raised the question, well, what happens if my subcontractor sells and they're no longer a similarly situated company? And what does that mean for, what are the ramifications under this proposed rule and under the contract? And the proposed rule doesn't drill down that far. What the proposed rule says is that the prime contractor has an obligation to notify the contracting officer. So while these similarly situated firms being able to team to meet the rule are a good thing, there are an awful lot of additional responsibilities put on the prime contractor to be certain that the subcontractors are doing what they said they were going to do, and then reporting back to the contracting officer if it's not the case. And the contracting officer also has additional responsibilities under this proposed rule, because in the past there has been really a lack of clarity as to whether this was an SBA requirement for enforcement or whether this was a matter of contract administration. And the new NDAA in this proposed SBA rule puts the onus squarely on the shoulders of the contracting officer and the small business prime contractor. So we have a question as to whether or not there is room to add a similarly situated entity post-proposal award. And I think that the question is absolutely correct. It's not really clear. And another question that I have and that we have been getting is, what happens on IDIQ contracts where you have no idea what the amount of work will be, what the amount of work per task order will be, yet this rule asks you to certify at the IDIQ contract vehicle level that you plan to comply and submit all of your SBTAs at that point. So it gives some flexibility moving along that you can change. I assume it means that you can add or substitute SBTAs, but it isn't really that clear.
Yeah, they say in the proposed rule it says that the utilization of the contractors that you've identified is not a material requirement, but at the same time it's requiring you to identify all these contractors up front, and that's part of the your proposal submission. You're certifying that you're going to be using them. So it creates some issues.
Next page.
So for compliance, more aspects for compliance. This is for the how are the limitations on subcontracting, how are they going to be calculated? What period of performance and measurement will the SBA is the SBA proposing to use? So the time period used to determine compliance for a total or partial set-aside contract would be the base term and then each subsequent option period. So you would measure compliance with your target percentage based on, so for example, if you have a base term of 1 year and 4 one-year option periods, you would determine the limitations on subcontracting for each period of performance. So for the base term, you would have to meet 50%. For each option period, you would have to use 50%. However, if you have IDIQ or multiple award contracting vehicles, the contracting officer maintains the discretion to require compliance for each order. So technically, or what the proposed rule envisions, is that it would be measured over the entire period of performance, base year, option year, etc. But for each individual orders, the CO can require you to comply. So for orders issued under full and open contracts, the time period will be for the period of performance for each order. So unless the order is competed amongst small and other than small businesses, in which case the limitations on subcontracting will not apply. And then also for the SBTAs, which Pam was mentioning earlier, and these are defined in the proposed rules as those SBTAs exempt from affiliation as a small business for reserve on a bundled contract. So it's not getting very specific at all here, but for SBTAs that are exempt from affiliation for reserves on bundled contracts, compliance will be measured on cooperative effort of all team members, not the efforts of individual team members. So
in answer to a couple questions here, let me scroll up. You guys are giving us a lot of good questions, and they're coming in fast. So let me see if I can go back to the one I was going to try to scroll. Okay, question is what impact is there on existing contracts? And also, when will this new rule become effective? So currently, the law is the law. So the law was signed by the President in 2013, 2012 probably, and it says that you can team with similarly situated contractors. The law also says that you have to comply with this new limitation on subcontracting. However, SBA's position is that we don't have regulations to implement this, so you need to wait. We have seen a couple contracting officers who have put something in the RFP that said that you may team with similarly situated in order to satisfy the limitations on subcontracting in accordance with the NDAA. But I would say that unless that's in your RFP, it's a little bit, you might be not in compliance if you go ahead and do that without a final rule. Now, even when the SBA issues a final rule on this, it should not be applicable to existing contracts. It should be effective for contracts entered into or maybe solicitations issued after the date of final rule. But generally speaking, the contracting officers do not look at 13 CFR as their law. They look at the FAR. So once SBA does their thing, then we need to have a FAR council review, and the FAR needs to be amended. So it may be that this is a way down the road issue, but it may be that it moves more quickly than that. So for limitation of subcontracting, another question, it must be met during each period of performance. So it must be met during the base period, and then it must be met during each option period. And if it's a task order contract, although it's not 100% clear, I think the SBA intended that for each task it must be met at the base period and then at each option period as well. Okay.
I think that for limitations on subcontracting, they do not apply for small business set-asides contracts between the micro purchase threshold and the simplified acquisition threshold, or subcontracts for those acquisitions. However, for subcontracts to similarly situated entities, the similarly situated entity must perform the required portion of the work itself. And the proposed rule also includes penalties for noncompliance, which would include a fine equal to greater of $500,000 or the dollar amount of subcontracting spent in excess of the permitted level. So there is some proposed penalties included in these rules.
And I would go a step farther. I think that the way it's drafted, they're sort of linking compliance back to that presumed loss rule that we've been talking about for the past couple of years. So if you say in your proposal and you certify that you will be compliant and you explain how you will be compliant and then you don't do it, it seems to me that it's possible that we could be looking at material misrepresentation cases which could be penalized under the False Claims Act, and I think that's the link here to this $500,000 or the greater of the amount that you're in violation. So if, again, it links back to you will want to comply as much as you can on your own, and then if you have a similarly situated contractor, you need to make sure that that contractor is vetted, that he understands the rules and regulations, that he has signed a teaming agreement that wraps him up to notify you anytime he can't comply, and that you have some mechanism available to monitor whether he is or he isn't in compliance. Now this next slide talks about the procedures for changing the limitations for a specific NAICS code. Again, as Katie said, the NDAA said that SBA may look at specific industries by NAICS code, and if it's not workable for the industry, gather data from the community and then issue a rule that might change the percentage for that particular industry. But remember that that takes a very long time. So if you're in an industry right now where you think this rule is not workable, now is the time to gather the anecdotals and to gather the information together and submit it to SBA, because once this proposed rule is implemented, it will be a long time before it's changed. And then you'll have different standards for different NAICS codes, which seems a little bit cumbersome. So let's go to concerns with the proposed rule. We sent out an email blast after we did a quick analysis of the rule, probably the early January, and we asked for comments back, and we got back lots of good comments and concerns about the proposed rule. One of the concerns is that the limitation on subcontracting for supply contracts is missing the statutory exclusion for cost of materials. Now, I think that the SBA rule discusses supply contracts, and they really are talking about contracts for manufactured goods. So a small business manufacturer needs to be able to exclude the cost of materials in order to be able to even come close to complying with the limitation on subcontracting. We had a client who was, a proposal was already due on a contract to manufacture and provide and service I think it was a spare parts type contract, and they said that none of the offerors would have been able to comply if the limitation was on the total contract price and did not exclude the cost of materials. So think about your industry and think about whether or not that would be a problem. Next question is, why is SBA allowing a firm to exclude supplies from a service contract but it has no exclusion for construction contracts? If we're reading this proposal correctly, the construction industry will be significantly adversely affected because there's no exception, and it suggests that if it's a $10 million construction contract, then only 85% of that $10 million can be subcontracted out or utilized for cost of materials. So that needs to be addressed. We also have clients that are in the remediation industry. And so if you are at a cleanup site and you are required to identify the hazardous materials and haul those materials away and then take them to a disposal site for disposal, you have a problem under this proposed rule because the hauling companies have to be compliant with the DOT regulations. Those are major trucking companies, not similarly situated small businesses, or a lot of times that waste needs to be transported by rail. So again, it's impossible that that would go to a similarly situated small business subcontractor, and then the hazardous waste facilities are not owned or run by small businesses. So those are just a couple of examples of industries where we have heard that there would be significant repercussions with this proposed rule. Another thing that I think we talked about before is how easy would it be to identify your similarly situated subcontractors on task order contracts. And so maybe we need to ask SBA not to have that evaluation done at the IDIQ level, but in fact at the task order level, at least not a certification at the IDIQ level. And then the question is on past performance. How will we evaluate past performance? Will we be allowed to utilize the past performance of our similarly situated subcontractors? And I think that that's going to depend on the terms of the RFPs. So we could stay on this rule, and hopefully we'll be able to come back and get answers to some more of these questions that you're asking. But let's switch to a few other proposals that are unrelated to the limitations on subcontracting rule that are in this proposed rule. Small business subcontracting plans.
So the proposed rule has some changes for measuring compliance with small business subcontracting plans, and this is mostly for large business prime contractors that have to submit these plans along with their proposal. Now the head of the contracting agency must ensure that the agency collects reports and reviews data on the extent to which prime contractors meet the goals and objectives of their subcontracting plan. So it's really more of a compliance push at the agency level. And there is some more precise penalties for not providing a written corrective action plan or demonstrating a good faith effort to comply with such a plan if you've already been determined to have been falling out of your limitations on subcontracting compliance. And these include the penalties that are already included in FAR 52-219-16, such as liquidated damages, material breach of contract has to be considered in a past performance evaluation, and even referral to the SBA IG if you've made a false statement about your compliance with your plan or haven't implemented your corrective action measures. And also, if a prime contractor identifies the small business by name as a subcontractor in its proposal or subcontracting plan, the prime must notify the small business in writing that it intends to utilize it. So this again goes back to the SBA's push to make sure that subcontracts with small businesses for these limitations on subcontracting goals are honored. The proposed rule also has some changes for how affiliation will be determined for identity of interest affiliation. It's basically some refinements on the way the rule already exists right now. So it's creating a rebuttable presumption of identity of interest affiliation through the family's relationships for firms that conduct business with each other and are owned or controlled by persons who are married, parties to a civil union, parents and children, or siblings. So they're really calling out these specific relationships, and they're trying to get away from the general, more totality of the circumstance, I think, determination for identity of interest with regard to familial relationships. It's also creating a rebuttable presumption of affiliation through economic dependence when one firm derives 70% or more of its revenue from another firm over the previous completed fiscal year. So this 70% figure is already sort of out there, so to speak. This is the SBA case law indicates that 70% is when the SBA will find a economic dependence on one firm with another. So this is just a formalization of that rule. And the proposed rule also says that this may be rebutted when the firm is a new or startup and has only received a couple contracts or subcontracts. So they won't be penalized for only having one big contract and having 70% of its revenue from that other firm that it has the contract with. But that's only for small, for startups or new firms, and we do, I think, need some examples in the proposed rule discussing well, what constitutes a new firm or startup. The proposed rule also has some changes for joint ventures. The SBA is proposing to permit 2 or more small businesses to joint venture for any procurement, as long as each procurement is considered small for the procurement. And the current standards with regard to when 2 or more small businesses can joint venture and still be considered small will remain, but also it expands the affiliation exception to any procurement regardless of size.
So just to drill down a minute on that joint ventures, basically what the rule is currently is that a joint venture is two companies that are joined together for a particular procurement, and unless that joint venture falls under one of the exemptions, you need to aggregate the revenues or the number of employees of both joint venture partners for purposes of determining whether that joint venture is small for that particular solicitation. And SBA is saying, hey, look, now if we can have similarly situated firms getting together to perform work and satisfy the limitation on subcontracting rules, why can't we have 2 small businesses get together and not have to have an exemption from affiliation? So let's just say that on any kind of contract or set aside, that as long as each individual firm is small, that joint venture is small. So I think that's what the SBA is attempting to do with that, with changing that. And again, though, we have to look at this now in light of the new mentor-protege rules, and there are some things that are inconsistent in the 2 proposals that will need to be smoothed out, and there are some things in the existing regulations that will need to be changed if we're going to accommodate these new rules. Someone's asking about daughter and son-in-laws. For that affiliation rule, it does not say that. It says children, not in-laws. So I think it would be carefully scrutinized, but there's not going to be a presumption of affiliation if we're reading the rule correctly. And again, people are asking for the slides. I know that this is like drinking from a fire hose, and we will be providing the slides to everybody. I think that we send them out after the presentation. and they're on the website. And if you have any follow-up questions, or if you want to send us comments, if you can do that, we will be submitting, and we can incorporate your comments into our proposed comments. And yes, if you want to send us your proposed comments, we would love to look at them before you submit them to SBA. Okay, this this new rule is on size recertification. It's on page 28 on your screen. Right now, the size of a small business is determined when you submit your proposal, including price. And the only exception to that is on long-term contracts, where you need to recertify at the end of year 5, and if there's a merger or an acquisition, in which case you need to recertify within, I think it's 30 days of the transaction being completed. Well, there was nothing ever in the regulations that said what you did with pending proposals. And this proposed rule says that if there's a pending proposal and you merge or you're acquired, then you have to notify the contracting officer. And that's all it says. It doesn't say what will happen or anything. But it seems to me that it's raising a lot of concerns and questions of timing with respect to, firms that are thinking of merging or being acquired. What happens to your pending proposals? I think we just have a couple more minutes. We may get shut off, so I'll keep going until we stop. NAICS code appeals. I'm actually going to skip this page. The non-manufacturer rule. Basically, I don't know that we have a lot of manufacturers on the phone, but the non-manufacturer rule says that the limitations on subcontracting do not apply to small business contracts set aside between $3,000 and $150,000. That doesn't apply to the other socioeconomic set-aside programs, though. And it proposes that where companies are providing products and they need a waiver of the non-manufacturer rule in order to provide the product of a large business, that the contracting officer needs to say so in the RFP. The contracting officer needs to say there is a class waiver so that you, small business supplier, can buy this, product from IBM or from a large business, because no small businesses make this product. Or I, contracting officer, have applied for a waiver because I know that there are no small businesses in this area that can satisfy this requirement. So if I get the waiver from SBA, you should be able to provide a large business product. That's called the non-manufacturer rule. And basically what this provision's doing is putting a requirement in that there's notification in the RFP. Software purchases, question is, well, do they have to come from other small businesses, or can you buy software from large businesses? And this proposed rule says if you're buying software, you need a waiver. On the other hand, if you are custom designing software, that's a service and you don't need a waiver. The ROTEC decision is a Court of Federal Claims decision that only comes into play because basically the Court of Federal Claims said that what I just told you isn't necessarily the case. The Court of Federal Claims says that whether or not it's a service contract or a supply contract, the Small Business Act says that you have to supply any products or services from a small business. And so therefore, even on a service contract, if there's a manufacturing or a products component to it, that should come from a small business. We don't like this decision. We don't agree with the rationale for it. The Justice Department decided not to challenge it at the Court of Appeals, and so what may need to happen is that Congress needs to tweak the Small Business Act to make it consistent with the regulations. So that's the end of the presentation. I know we didn't answer all of the questions, but we will try to get an email to you with the answers. Some of them we may not have answers, and we'll again encourage you to submit comments to SBA and feed information to us if you would like. Thank you very, very much for listening and for joining us this afternoon.